Hi, we had a brief delay due to an illness, so then it's probably going to be another 5 minutes before we start. I apologize. We're waiting for a third person to join us up here. Sorry. In orders following the pre-hearing conference? Okay, because I'll go over that before we start. At this point, I just wanted to make sure that everyone had a chance to read that document. Okay, great. Thank you. Okay, so the third administrative law judge is going to be Tommy Leung. And since he wasn't listed in the notice of panel that went out, I just want to, at this point, make sure that there aren't any objections for cause or conflicts that that either party knows of with Administrative Law Judge Tommy Leung. Okay. Okay, perfect. Thank you. Hi. Looks like we're ready to proceed. I apologize for the delay. And welcome to the Office of Tax Appeals. My name is Andrew Kui. To my left is Sarah Hosey. And
Good morning.
To my right is Tommy Leung.
Good morning.
And we are the administrative law judges who will be conducting this appeal for OTA. OTA is a separate and independent agency from CDTFA, and our role today is to conduct and decide this appeal. In a few minutes, we will go on the record. By on the record, I mean that a certified shorthand reporter will be transcribing what is said today. This transcript will become a part of the public record and will be viewable on our website. After we go on the record, I will ask the parties to identify themselves and who they represent. But first, I'd like to go over the topics from the pre-hearing conference. And I understand that everyone did have a chance to read that. Based on what was discussed at the pre-hearing conference and the parties' briefings, I understand that we're just having oral arguments today, that there aren't any witnesses that are going to be called to testify today, as NCDTFA has indicated that they have no witnesses. Does the taxpayer have any?
We have no witnesses.
Okay. So on the exhibits, CDTFA had exhibits A through H, and I believe I don't have any exhibits for the taxpayers. Is that correct?
That's correct.
Okay, and CDTFA, you don't have any additional exhibits at this point. Is that correct? Okay. So, and there's neither party has any other materials to distribute at this time?
Not that I know of.
Okay.
No, sir.
Okay, great. So, in the pre-hearing conference minutes and orders that I sent out, basically, so I reviewed the briefing and the exhibits, and based on my review, I understood that the facts are really not at issue, and that this is more of a legal issue. So I summarized what I understood to be facts that the parties agreed to and did not dispute, based on my review of the briefing and the exhibits. And I just, at this point, I'd like to confirm if that understanding is correct, or if there's any concerns that either party has with the summary of facts that I ascertained from the record.
By and large, I agree with what was put in the minutes.
Okay. And CDTFA, do you agree that I have accurately summarized the facts in this appeal?
Yes, and I believe we filed a response to your minutes.
Oh, okay. Yeah, that's...
Yes, no
yeah,
objection.
You are correct. So when we go on the record, I will ask the parties to confirm that they do agree to these facts, just for the record, and OTA will thereafter accept that these facts are correctly summarized so that we can focus on the legal issues in this appeal. So if I have a question for CDTFA. If the parties are stipulating to the basically these facts, it seems like we don't need the audit work papers, which are your exhibits E through H. I'm just wondering if you mind if we strike those exhibits because the facts in this appeal don't seem to be disputed.
Yeah, that should be fine. Yes.
Okay, great. So we will when we go on the record, we will strike exhibits E through H for CDTFA, and those are the audit working papers. And did either party have any concerns with the phrasing of the issue? And that was the issue that I have summarized for this case, was whether appellant should be liable for sales tax on its sales of vehicles at retail in California when it did not collect any amount for sales tax reimbursement from its customers, and the customers did not register the vehicles in this state. And that's the issue that I believe we're deciding today. Is that correct for the taxpayer?
I think it's a little bit more nuanced than that, but I think that's a good effort of stating it.
Okay. And CDTFA has indicated it was they were okay with that phrasing.
Correct.
Okay. And as far as time estimates, since there's no witnesses, I was planning on having the taxpayer do an opening presentation, followed by CDTFA doing an opening presentation, and then each party would be afforded 5 minutes on rebuttal, basically as closing arguments. Does that sound fine with the parties?
Fine.
Okay, and how much time would the taxpayer like, or how would you like for your presentation?
I don't need very long. I need about 10 minutes.
Okay, perfect. So with that said, I believe we're ready to go on the record. Does anyone have any questions for me before we start today?
No, sir.
Okay, great. So,
Hold on, I have one question.
oh, okay, 1 second.
If I make reference to something, and it turns out that someone's unaware of it or more information is needed, will I be able to then offer it as needed?
Are you referring to offering new evidence at the?
Well, I mean, I'll speak in specific terms. The taxpayer was audited for the period that we're discussing now, but they were also audited for the following 3 years as well. And I will make reference to that audit in what I say. So I don't know if we need to pull the audit papers or do anything for anything like that. But CDTFA, obviously, being the successor to BOE, should be well aware of the existence of that audit. So.
Right, and so we can't make a factual finding based on evidence that is not in the record, and we don't have those audit files for a subsequent audit in the record, but to the extent that both parties agree to those facts, we can accept them as correct. And so if there is an issue that actually requires some sort of information from the subsequent audit, we can address that when it arises. But if not, you're free to make references to the subsequent audit during your presentation. To the extent there's a dispute, we can't make a factual finding as to what occurred during that third audit, subsequent audit, though.
Understood.
Okay. So I believe we're now ready to go on the record. So we're opening the record in the appeal of Carsmith, Inc. before the Office of Tax Appeals. OTA case number is 18011929, and today's date is Tuesday, August 27th, 2019. The time is approximately 10:20 a.m., and this hearing is being convened in Sacramento, California. For the record, will the parties at the table please state their names and who they represent, starting with the representative for the taxpayer, Carsmith, Inc.?
My name is Mark Francis, and I represent the taxpayer, Carsmith, Inc.
Good morning. Thank you.
My name is Jarrett Noble. I represent the California Department of Tax and Fee Administration. And to my left is Monica Silva and Lisa Renati.
Great. Thank you. So today's hearing is being heard by a panel of 3 administrative law judges. To my left is Sarah Hosey, and to my right is Tommy Leung.
Morning.
And my name is Andrew Kui. Judge Hosey and Judge Leung are the other members of this panel, and I will be the lead judge. All 3 judges will meet after the hearing and produce a written decision as equal participants. Although the lead judge will conduct the hearing, any judge in this panel may ask questions or otherwise participate in this hearing to ensure that we have all the information needed to decide this appeal. So the documentary evidence that we have marked for identification includes no exhibits for the taxpayer and exhibits A through D for CDTFA. There are no objections that were raised to the CDTFA's exhibits, and the parties have also agreed to the statement of agreed facts as summarized in OTA's minutes and orders for the pre-hearing conference. And the parties agree that these facts are correct and not disputed. The exhibits are also listed in the OTA's minutes and orders, subject to the caveat that we were striking exhibits E through H from the exhibit index listed in that document. Will the parties please confirm for the record that the summary I have just provided is correct and that they have no objections to admitting any of the evidence into the record that I just described, including the statement of agreed facts, starting with counsel for the taxpayer?
I confirm and agree.
Okay, and counsel for CDTFA?
We confirm and agree. No objections.
Great, thank you. So the above evidence is now admitted into the oral hearing record. At this point, I'll go over the issue statement, and that issue statement is whether the taxpayer should be liable for sales tax on its sales of vehicles at retail in California when it didn't collect any amounts for sales tax reimbursement from its customers, and the customers did not register the vehicles in the state. So we are at this point ready to proceed with the taxpayer's opening presentation. The taxpayer will have approximately 10 minutes, and I will not be swearing anyone in today because we're just doing oral arguments. So with that said, please feel free to proceed for the taxpayer.
Okay, thank you for your time. As it pertains to the case in question, as we have already mentioned, the taxpayer does not disagree with the findings of the 2008 to 2010 period audit and the assessment that has been laid upon them, so to speak. We do not dispute anything that was laid out in audit. We think that was actually a cleanly and correctly done audit. Ultimately, it took some time to get to the final amount, but at this point, we agree with it. What is at issue, and the taxpayer would like to have put on the record, is that their erroneous assumption, and again, they're accepting culpability for their error, that registration of the vehicle in a foreign state was sufficient to qualify it as out-of-state sales, therefore not subject to tax in the state of California, was their fallacy. And they conducted a decent amount of business where vehicles were delivered out of the state, which does comply with the definition of an out-of-state sale. And they had some transactions that were where the vehicle was driven out of the state, and those obviously do not comply with the definition of out-of-state sales. They were unaware of that. Their confusion was aided by obviously not knowing the existence of a DMV one-trip permit, which allows a vehicle to leave the state, and the fact that they were aiding their customers in registering their vehicles in the states where they were being required to pay sales or use tax. And so they, in their mind, they were assuring that tax was being paid on the transaction, what they thought was correctly. And so that's what resulted in the findings from the 2008 to 2010 audit. The taxpayer was again audited for the tax periods 2011 to 2013. And because the 2008 to 2010 audit didn't conclude until 2012, the taxpayer continued to do business in 2011 and 2012 under the same, ignorance of what constituted out-of-state sales correctly. And so the audit of 2011 to 2013 called to attention those very same things. The auditors were perfectly aware of the situation from 2008 to 2010, knew to look for transactions of similar nature, and identified several of those as well. In that audit, they asked for the taxpayer to prove the cars were ultimately registered. We did a little research and determined that the cars had in fact been registered in the states they were sold to. And they found for no change on that audit, and so the taxpayer is frustrated and confused that there would be two different findings for the same set of circumstances. They realize that the law supports the first findings from the first audit more than it does from the second audit, but it underscores the issue at stake here, which is that the rules surrounding out-of-state sales for vehicles are very confusing and difficult for taxpayers and business owners to understand clearly. I think it's not a stretch to say that it is kind of unusual that a car could be delivered on a truck to the state line and not be a taxable transaction in the state of California versus one being driven to the state line and across the state line and subsequently registered into that state that it drives across to and have it be a taxable transaction. It's not inherent. It's not something that I would expect an average person to know. I understand that it's on the taxpayer to know the tax laws, but at the same time, the state is in business with the taxpayer, and there's it's kind of a two-way street as far as that goes, in my opinion. The BOE, the CDTFA's predecessor, never reached out to the taxpayers when the business was formed or at any time along the way to stress that the out-of-state sales rules are complicated and confusing, and that they should be careful not to accidentally expose themselves to a tax liability for a tax they never collected and can't pay. Lastly, I would just say that Carsmith has been in business since 2002. It has remitted approximately $14 million in sales tax to the state of California. It has filed all of its sales tax returns timely and paid all of its sales tax timely and correctly, with obvious exception of the matters that we're here to discuss. And they've been a good business partner for the state of California. So that's pretty much all I have to say on the matter at this time.
Okay, thank you. And if I could just get one clarification on your argument. Were you saying, if I understand correctly, that in a subsequent audit under the same facts, CDTFA accepted the transactions based on an allowance for a tax paid to another state, but in this audit it was treated differently?
I'm saying that the Board of Equalization did that. It was the BOE at the time. But
okay.
I'm saying that there were transactions of the same nature in that audit, and they were discussed between the auditors and myself, and they issued a no change. That's correct.
Okay. briefly before we go to CDTFA, I'm just wondering if you're at all prepared today to talk about the subsequent audit and address this point that was this issue that's being raised.
We're currently trying to verify whether it was an actual audit, where audit working papers where it exists, versus an initial examination of documentation and a determination that an audit would not be conducted.
Okay. So at this point, would you like to proceed with your presentation, or would you like a brief recess to discuss this before you start?
Yep, sounds good. We would like to proceed while
Okay.
we're discussing the audit period at issue in which the sales have been conceded as subject to sales tax.
Okay. Please proceed.
Under the Revenue and Taxation Code, sales tax is imposed on a retailer's retail sales of tangible personal property in this state, measured by the retailer's gross receipts, unless the sale is specifically exempt or excluded from tax by statute. A retailer's gross receipts are presumed to be taxable until proven otherwise, and the burden is on the retailer to establish that its retail sales are not subject to tax. Sales in interstate commerce are exempt from sales tax when, pursuant to the contract of sale, the property is required to be shipped and is shipped to a point outside this state by the retailer or the retailer's delivery of the property to a carrier, customs broker, or forwarding agent for shipment out of state. In this appeal, there is no dispute that the 46 sales remaining at issue either involve sales in which the customer took possession of the vehicles in California and drove the vehicles to out-of-state locations, or sales where there is no documentation establishing that the sales were non-taxable sales in interstate commerce or were otherwise exempt from tax. For the sales where the customers took possession of the vehicles in California, the sales occurred in this state when appellant delivered the vehicle and title passed. Accordingly, appellant is liable for sales tax on these transactions. As for the sales to which there is no documentation, appellant has failed to meet its burden establishing that the sales are not subject to tax, and there is no basis to recommend adjustments to the deficiency measure for these sales. As for appellant's assertion that it should be granted equitable relief from the tax liability because it did not collect tax reimbursement from its customers, we first note that CDTFA is bound by law, and there is no statute or regulation granting relief from the tax liability based on the issues in this appeal. Second, while a retailer is authorized to collect tax reimbursement on its retail sales, the sales tax is imposed on and owed by the retailer, regardless whether tax reimbursement is collected from the customer. There is therefore no legal basis for further adjustments after the recommended adjustments as set forth in the second supplemental decision. As to the remaining liability, this appeal should be denied.
Okay, and I'm just briefly, does the department have any position on whether, if the taxpayer established that tax was paid to another state at the time the vehicles were registered, any allowances would be warranted, since the taxpayer, I guess, is arguing that an allowance was given in a subsequent audit for that type of scenario?
It's unclear what's going on in the secondary audit, even if there is one. My interpretation was that he alleged that when registration was shown out of state, that they assumed that the sales were delivered out of state. That's not the same as getting an offset for tax paid out of state. I don't believe with the sales at issue we have any evidence that tax was paid out of state, although there had been some evidence of vehicle registration out of state. If we had evidence that tax was paid to another jurisdiction, such as another state, CDTFA would need time to respond to that. That would be use tax remitted by the purchaser versus sales tax reimbursement that would have been owed by the retailer. But we would need to see evidence that tax was paid to another state first.
Okay. At this point, I'd like to see if either co-panelist has any questions.
No questions, thank you.
I've got a question to both parties. Given the fact that there's a very fine distinction between having a consumer pick up the car in California and having the car put on public carrier, like a tractor trailer carried across state lines, does CDTFA provide any type of brochure, publications, whatever, to car dealerships to explain this to them?
CDTFA has publications on its websites, both for vehicles, vessels, and aircraft that deal with use tax generally, and they have publications specific to vehicle dealers that go through interstate commerce sales and out-of-state sales. And generally, when a retailer opens up their seller's permit, they're given different publications about the rights and obligations that they have to do business in this state at the time that the seller's permit is opened.
Thank you. And for the taxpayer, did you read those publications? Did you have access to them?
I've since read them.
So,
Well, the taxpayer's been in business since 2002. I have been their accountant pretty much the entire time. What was provided to them by BOE in 2002 is not of knowledge to me. However, as a practitioner, I'm aware that when one opens a sales tax account in the state of California, documentation is provided. Whether vehicle-specific information was provided to the taxpayer, I certainly can't say.
okay. So what exactly are you asking from us?
Well, basically, the whole point of my being here is two things. First of all is to get certain things on the record, and second of all is for a plea to reasonability, which is what I have been asking for at every step of the appeals process. The taxpayer is left holding the bag on a very large tax liability that threatens the very existence of the business. I don't expect you to be super sympathetic to the fact that they made an error, but I do expect that the circumstances surrounding it be considered such that the taxpayer made effort to ensure that the vehicles were properly registered in their state and that tax was paid in those states. They knew tax was due somewhere. They did not know where, and they made a mistake. And the penalty for their mistake is $106,000 as it stands right now. To me, that seems harsh. The audit papers from 2008 to 2010 indicate that the taxpayer was cooperative at every step of the way and that they were helpful and forthcoming with regards to the information. The same thing was true in the 2011 to 2013 audit. As I've noted, the business has been around for 17 years. It has remitted $14 million to the state of California. It is a good business partner. When I was in line for a hearing with the BOE before I got pulled off the docket and the whole format changed, I worked with Fiona Ma's office in San Francisco. They were very sympathetic to the taxpayer's case. I made contact with George Runner's office and began to introduce the case to him. They were sympathetic to the case. So my point of being here is simply that the law is absolute. If you want to apply the law, which is absolute, then you're going to find against me and show me to the door. But if you want to consider what happened and consider the people doing the business at Carsmith, Dave and Kevin, the owners, Jeff and Brian and Arlen and Eric, good people who were trying to do their job and made a mistake, then perhaps somebody can step in and treat the situation reasonably. Should they be penalized for their mistake? Yeah, maybe, probably. Who knows? That's up to other people besides me. It's an honest mistake, and none of us are perfect. I don't think they should be penalized at all, speaking candidly. But should they have to pay sales tax that they cannot collect from customers who registered their cars in other states and paid tax there? I mean, there's no remedy for the taxpayer. And the state of California, in my opinion, is being unreasonable in asking that they do that. And given the nature of confusion surrounding out-of-state sales and the fact that the Board of Equalization conducted 2 parallel audits with basically different findings. And CDTFA can discuss the semantics of the second audit all they want, but the auditors came to that audit fully aware of what happened in the first audit, and the taxpayer was continuing to conduct business until they were made aware of their error in the exact same manner until that audit found against them and were unable to correct it. And those auditors were keenly aware of those transactions. There was no showing them that the car was registered in Colorado, for example, and them thinking that it was delivered on a truck as opposed to driven out. They were keenly aware of the circumstances. So those auditors, whether they were doing the job correctly or not, acknowledged that the situation was confusing and didn't seek to further punish the taxpayer. So what I'm asking for is that reasonability prevail and that the taxpayer be dealt with fairly here, and that we not apply the law mechanically, and that we consider the facts and circumstances surrounding the case.
So just a quick clarification with the CDTFA, there's no penalties at issue in this case, is that correct?
No, there are no penalties at issue, and I wanted to note that there was no audit working papers for the audit. An audit wasn't conducted. There was an initial record examination, and no opinion was issued whatsoever. So for the secondary.
So you're
audit
saying it was a
period.
no opinion. Okay.
Yeah.
We were able to confirm that.
So they didn't actually officially examine records and go and conduct an audit and make a finding.
Okay. Well, as I did state, since we don't have evidence on the subsequent audit, we can't make a factual finding as to what happened at that time in absence of documentation or agreement between the parties. But I did have a question for the taxpayer. Would you still have records of tax paid at the time of registration on the disputed vehicles?
We have some. I mean, so basically, in the course of the audit and the appeals, we have gotten customers to provide some of that information for the purpose of basically, building our case, so to speak. And in the case of all the vehicles, we traced their registration ultimately to the state in which they were sold to, so we knew that they had been registered there, and we're aware of the registration rules in the states that they were registered in. In other words, use tax being properly remitted at the time. Had it been an issue that would have been accepted at the time, certainly we would have went back to our customers and gathered that information, because our customers like us. We have a good reputation in the community, and we do business the right way. So if we were to try and piece it together for all of the transactions now, it's 10 years later, so we might not be perfect in doing it, but I bet we could pull some of it together.
Okay, and I guess at this point I would ask CDTFA if the taxpayer were able to provide that type of information, is that something which would change CDTFA's position at all, or potentially change CDTFA's position?
CDTFA would like to see the evidence and then have time to respond if necessary. As I said before, these sales are California sales tax transactions in which California sales tax was imposed.
Okay.
The taxpayer, the appellant, would not have been the one paying use tax to another state. It would have been a different individual. 6406 is the statute that deals with offsets for a tax paid to another jurisdiction, so we would have to analyze that issue. But again, we'd like to see evidence that tax was paid, not just registered in another state.
Okay. At this point, do you mind if we took a brief 5-minute recess?
No problem at all. Thank you.
All right, thank you. before I go back on the record, did CDTFA want to ask a question?
Oh,
We can wait till
we can wait till we're on the record. We wanted to clarify our position
Okay.
on 6406.
let's see where we go.
Okay, so we're ready to go back on the record now. So at this point, I believe CDTFA has a clarification to make.
Yeah, California Revenue and Taxation Code Section 6406 is the statute that addresses tax credits for tax paid to another jurisdiction, and it's person specific. So in this case, the retailer appellant didn't pay any use tax to another jurisdiction or sales tax to another jurisdiction. So there would be nothing to offset here. The purchaser would have been paying their own use tax out of state.
Okay, thank you. And at this point, I believe we're ready to proceed to closing arguments. I'm sorry. I should ask the panel if either member has a question before I proceed.
No question. Thank you.
Okay, so at this point, I'll let the taxpayer start with their closing arguments.
Thank you. Judge Leung got most of my closing argument out of me when he asked me what I was here for. So I will be brief and first thank everybody for their time. I wish we didn't have to be here for this, but unfortunately here we are. This audit started a long time ago, and I think it's 7 years later. I'm still upside down. Thinking about it, it's a matter of great passion to me. I represent the client pro bono. I feel very strongly about how adversely affected they would be by having this tax found against them. I think I've made a good case as to, during the audit and in all subsequent steps, as to how the laws of the state of California are regarding out-of-state vehicle sales are confusing. I think I've made a good case that the taxpayer cannot pay a tax that they did not, cannot remit a tax that they did not collect, and it is very difficult to go back to a customer who has since paid applicable taxes in their state of registration to pay more tax on top of it. There's no remedy for what is being asked here. The business is a business that lives hand to mouth. I'm sure the financials were examined in conjunction with the audit. This isn't a huge car dealership. This is a small, closely run business with a handful of people working hard trying to make a living just like the rest of us. They were not involved in some elaborate ruse to avoid tax. They were unaware of the rules, and while they're being unaware of the rules doesn't necessarily excuse them. The saying that the punishment does not fit the crime seems clearly at play here, and I've done everything I could to try and resolve that matter prior to being here in a courtroom on the record and stating these things. But when I tried to negotiate a penalty, rather than the tax be paid, a reasonable one to affect the taxpayer, I got laughed at, basically by the lawyers for the BOE, and so here we are. And again, Carsmith, good partner with the state of California. $14 million of sales tax remitted successfully, timely filings consistently, timely payments consistently. If you did any research on the dealership before you came here, good references from people who have bought cars from them, good people. I would think that the state of California wants to continue to do business with Carsmith, Inc., but if they proceed with the levying of this sales tax amount to liability to them, it will put them out of business, and you'll be forced to deal with whatever their replacement business is and start collecting tax from them, and hopefully their record will be as good as Carsmith's if that's the case. Thanks again for your time. I really do appreciate it.
Okay, thank you. At this point, we can turn to CDTFA for their closing arguments.
As we stated before, we reiterate the same arguments made in the opening presentation. There's no legal basis to relieve a retailer from their sales tax liability because they failed to collect tax reimbursement from their customers. There's just no legal basis to make adjustments to the measure. That's it.
Okay, thank you. I believe we're ready to conclude this hearing. Would either co-panelists like to ask any final questions before I close?
No, thank you.
I'm good, thank you.
Great. This case is submitted on August 27th, 2019. The record is now closed. Thank you, everyone, for coming in today. We'll try and issue a decision within 100 days from today.
Thank you.
Thank you.
Thank you.
Thank you.